Hi, and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeff Palomo. I would like to thank you for joining us today on the podcast. Before we begin, I'd like to just remind everybody, please don't take any advice that you receive from this radio show, or any other radio show for that matter, to constitute legal advice. This radio show does not create an attorney-client relationship between you and our firm, and that if you're looking for legal advice, you should seek an attorney that is licensed in the state that you live in and that you reside in, and seek specific advice for your situation. This radio show is meant, and podcast is meant for informational purposes only, and we hope you enjoy the show. So today, I want to talk a little bit about probate versus non-probate. Very, very common question that comes up in an estate planning and elder law firm. And no matter how much we talk about it, I feel like it is definitely one of the most easily misunderstood concepts that exists in estate planning and elder law. So I wanted to just talk a little bit about it today. First of all, it does not mean non-taxable. So it's very important for me to make sure to get that out there, because I think what happens is people assume if they avoid probate, they avoid tax, and that is not the case. Pennsylvania inheritance tax is the tax that applies in the state of Pennsylvania, and it is a tax on the transfer of wealth, depending on the relationship to whom is receiving the money. So if we're transferring wealth to a spouse, it's a 0 rate. To lineal descendants, children, grandchildren, parents, grandparents, 4.5%. Siblings is 12%. And anyone else in the world, including those lovely nieces and nephews, is 15%. Okay? Now, as a general statement, the only asset that is not taxable for inheritance tax purposes is life insurance. So as it relates to life insurance, that is not going to be subject to inheritance tax, and furthermore, not subject to creditors, or not available to creditors, should I say. So life insurance, not taxable, not available to creditors. Pretty much every other asset in the world is going to be subject to inheritance tax, whether it's probate, non-probate, whether it's an annuity, whether it's a retirement account. At the end of the day, if it's not life insurance, it's going to be taxed at the Pennsylvania inheritance tax rates, depending on who is receiving it. Now, from a federal perspective, it's very different at the moment. Currently, as we sit here today, a person can die with $12.06 million and not have to worry about a federal estate tax problem. And if you're married, 12.06 plus 12.06, which is a lot of money. And frankly, I do not have any clients that have that kind of money, so we're not going to worry too much about the federal estate tax. Suffice it to say, you're looking at about a 40% tax these days if you're over that amount of money. For the rest of us, we are really mostly concerned only about the inheritance tax, because it does tax from the first dollar, meaning there's really no, amount of money that's exempt, or the first so much is given for free. Pennsylvania gets their hands in it from the very first dollar and is going to collect their money based upon the relationship of the person receiving it on the rates that we mentioned. All right, so what is probate? Okay. Well, anything that's not non-probate. No, joke never gets old. Probate is anything that is in the decedent's name alone at the time of their death. And there's no beneficiary listed on it. There's no joint owners listed on it. It is in the person's name alone at the time of their death, period. That is what goes through probate. Probate is the state's rulebook. Probate is the government's attempt at telling us, okay, you have an asset in your name alone. What do you need to do to get it to the beneficiaries? What are the steps that you need to take to get it to the people who are going to receive it? Okay. So, for example, Pennsylvania says that the executor, if he's male, executrix if she's female, will fill out a probate petition. They will go down to the courthouse. They will take an oath. The oath goes something like this, depending on the county. Will you duly administer the estate and abide by provisions of law relating to inheritance tax? I will. Please sign here. The executor, executrix signs on the applicable line. The attorney who was there will sign on the attorney line as well. And, 15, 20 minutes later, the individuals from the Register of Wills office will provide what is called short certificates. And they are essentially what we call Willy Wonka's golden ticket. It now gives the authority to the executor to do whatever he or she needs to do on behalf of the estate. Okay? They will grant full letters, which typically will stay in the lawyer's file. The short certificates are what's used by the executor to go and close bank accounts and do those types of things. They'll actually have the short certificate with them, and if they need more, they can get more. Probate is that process. Probate is the law that tells us essentially what needs to be done. Okay, we have 9 months to file the inheritance tax. We can get an extension up to 15 months if we absolutely need to. There are some notices that have to be given. Notices to heirs, notices to creditors. You're going to want to advertise the estate in a paper of general circulation as well as in a legal authority paper. That way, you're providing notice to potential creditors so that they must come forward in a certain amount of time or forever hold their peace and they can't get any potential claims that they're looking for. Whenever everything is taken care of, the inheritance tax return is filed, distributions are made to beneficiaries, then they will ask the family members who are receiving the money to sign a family settlement agreement or some sort of receipt and release that they've received the money, that they believe that the executor and the attorney did everything correctly and the right way. And essentially at that point, there's a notice, a 5.2 notice that gets filed saying that everything was taken care of and we are complete. We have finished the probate process. So probate is essentially the rules that dictate all of that, how it has to be done, when it has to be done, why it has to be done, and in a certain way and those things. What is non-probate? Well, non-probate is any asset that is either jointly owned, has a beneficiary designated attached to it, such as life insurance, annuities, and other non-probate assets like 401ks, 403bs, IRAs. All of those are either going to be jointly owned, that it's going to transfer automatically to the joint owner, or beneficiary designated, that it's going to transfer automatically to the beneficiary. Now again, non-probate doesn't mean non-taxable. If I'm a joint owner with a child, what's the rate when I die and it goes to my child? 4.5%. Now, I owned half, the child owned half. So only half of it's going to get taxed at 4.5%. But there's still a tax, right? Don't think just because you're the joint owner that there won't be a tax. The problem is there's usually not an estate that gets raised. So there's usually not an attorney involved. The asset transfers automatically. The joint owner goes into the bank, closes the account, takes the money, or simply, takes the other person's name off of it or whatever they're going to do with the money. And they now have the money, right? They have own 100% of that account. Well, a lot of times they don't realize they're going to get a love letter from the Department of Revenue. What's a love letter, you ask? Well, a love letter is the letter that says, we were notified by the bank that you were a joint owner on an account with a decedent, and because of that, you have to pay inheritance tax at whatever rate's applicable based upon your relationship. Now, they tend to always put that it's a 15% rate. Well, if you're listening to the podcast today, you know that 15% is the rate for nieces and nephews and anyone else in the world. So they're counting on the fact that you're not going to realize that you can change it and provide what your actual relationship is and why it should only be 0 for a spouse, 4.5 for lineal descendants, 12 for siblings. So first and foremost, you want to pay attention to the fact that that love letter is not always correct. In fact, 99% of the time, it's at the highest rate, which is usually incorrect. But maybe more importantly, a lot of times people didn't realize they were going to get that letter. They thought they got off scot-free. They figured there was no way the Department of Revenue could have known because there wasn't an estate. There were no attorneys involved. So that's one problem about doing it that way is people don't realize that they're going to owe inheritance tax. Same with the beneficiary designation. Remember, the only asset that's not going to be taxed for inheritance tax purposes is in life insurance. So if you're the beneficiary of the life insurance, you're good. But if you're the beneficiary of an annuity, of a retirement account, of another non-qualified account that has a beneficiary listed, you're going to be taxed at the applicable rate of your relationship. And if no estate was raised, that love letter is going to come in the mail from the department. And again, you want to check that rate to make sure that it's not the highest rate. Tell them what the appropriate rate is and what the tax is. Well, we have seen numerous cases where several, months went by and people spent the money. People weren't expecting the inheritance tax piece to it. And I completely understand why the advice, generally speaking, is to avoid probate, right? Avoid the hassle. Avoid having to go down to the courthouse. Avoid having to get a lawyer involved. But by skipping it, by trying to get around it, a lot of times you're putting beneficiaries in a very precarious situation because all of that was skipped, which now leads them to believe that when they get that money, it's free and clear. And if it's life insurance, it might be. But if it's anything else, there is going to be tax owed. So, I think that sometimes we avoid a process simply because people tell us that we should. All right. So let's talk a little bit more about that. There are several pundits nationally who get on their talk shows and they have a huge following and they're telling people, you must avoid probate. You need a living trust. You need to avoid probate. It keeps the money from getting in the lawyer's pockets. It keeps the money from getting in the county's pocket, the state's pocket, and you're way better off. Now, on its face, you got to be careful using absolutes, but for the most part, the people who are indicating that that's the case not only are great pundits, but they also are joint owners of national companies that do trusts, that do living trusts. So is the advice that they're giving the right advice for everybody? Or is it what's the best interest of the company that they own, which happens to be a legal company that drafts living trust revocable, primarily revocable? I don't know. I guess we'll never know whether it's because it's the right thing or because they're just trying to put money in their own pockets. But what I do know is that you can't make a general statement that fits across the country because every state's rules are different. So I was blessed years ago, or unfortunate, I guess, depending on your perspective, that I was able to travel the country teaching lawyers. And the reason that I was able to do that is because I was teaching federal Medicaid rules under the Uniform Trust Code. And so I was teaching rules that are federally drafted, federally promulgated, and then there are, maybe nuances. But for the most part, I was teaching the federal rules or the Uniform Trust Codes, which most states adopted in the country. Well, to make a general statement like, everyone needs this is a little reckless, because the truth is every state's rules are different. And I will admit, some states' probate rules are horrendous. You have to go into court, get a judge to sign off. You could make months, if not years in some states, and pay tons of extra money. Pennsylvania is actually not a bad state at all to go through probate. It really isn't. I mean, a 10-minute appearance at the Register of Wills office in York, Lancaster County, where the executor raises his or her right hand, is essentially the only difference between what we need to do in probate and what we need to do in trust administration when a person dies, if we have a revocable trust, right? So when you think about it, well, now wait a minute. Everything is the same. I mean, we literally have a guide that we give to our clients, and we lay the rules side by side. What are the rules for probate administration? What are the rules for trust administration for a revocable trust? They are identical, except for that meeting at the Register of Wills office, which, like I said, in York and Lancaster County, 10 minutes. That's it, right? So from a legal perspective, the costs are very similar. The work is identical, other than one 10-minute meeting. So that's not necessarily true that they're going to save a ton, right? Now, I will acknowledge the state that she in particular that I'm thinking of resides in is California. And everybody that I have spoken to who practices in the state says, if you don't avoid probate in California, you have committed malpractice. Okay, I got it. There are several other states that are like that. Pennsylvania isn't necessarily one of them, okay? And even the fees to the county, right? So the fees to the county in probate, if we're under $25,000 but less than $50,000, it's $135. If you're over $50,000 but under $100,000, it's $100, and then each additional $100,000 or fraction thereof is an additional $100. So you're not talking a huge amount of money in probate, right? It really isn't substantial, and it doesn't really get to be an absorbent amount of money. And like I said a few minutes ago, when you're dealing with probate administration versus trust administration, the work for the lawyer is almost identical. So it's kind of similar in terms of costs on that end as well, okay? So what we're discussing today is probate versus non-probate. And the reason that I wanted to discuss it is because a lot of advisors and other professionals are encouraging their clients to avoid probate at all costs. Now, the one comment that I want to make is, in some instances, that's great advice, right? When we do Medicaid work, and we have done several podcasts on Medicaid, the state has a right to estate recovery, but only after the probate estate of an individual. So, okay, great. If we can avoid probate, we've now avoided the ability for the state to be able to come back and recover monies for someone who has been receiving care for long-term care in the state of Pennsylvania. Okay, that's wonderful. But outside of that, a lot of times what happens is we beneficiary designate everything to an individual. But the problem is that money now goes outright to them, right? So let's, for example, say that I leave everything to my wife, okay? Everything goes direct, beneficiary designated, non-probate to my wife. Well, who receives it? My wife does. Wonderful, right? Exactly what I would have wanted. Now, when I grew up, I was a lifeguard in Wimber, Pennsylvania, and then ended up being the manager at the water park at Lake Racetown. And I love pools. I love water parks. I hate chemicals. I went to get registered and to be able to administer chemicals and work at a pool. And I did it for several summers, and I just don't love it anymore. You know, if I have to test chlorine or pH, it'd be too soon if it never occurs in my life. And so every spring, what does my wife want? she wants a pool. And every spring we have the same conversation, which is, no, we're not going to put a pool in, right? But if I die and everything goes to my spouse, what's the first thing that she's going to insert or put in after she grieves for a reasonable amount of time? You got it, a pool, right? You knew it, you got it. And what comes with every pool? A pool boy in a Speedo, right? And all of a sudden now, she forgets about me. And she's with Biff, right? And where does all the money go? To Biff. Now, I'm obviously stating a story for effect. And we all laughed, and it was a good story. But strip away the laughter, right? I want my wife to be happy. I want her to do what she wants to do. But I don't want a new boyfriend or spouse to get all the money that I worked for. I want it to go to my child. And certainly I want my wife to be happy. But I don't want her to be able to give it to him. Right? I didn't work that hard for someone else, for another man. So we want that money to be protected. But the problem with just blindly beneficiary designating everything is that it goes outright. Now, let's say we leave the money outright to our children, right? And they end up getting divorced. They end up in a car accident. Just because you avoid the probate process means that now the only way to get it to the individual is outright. And as you listen to these podcasts, as we go on the Red Wagon Estate Planning and Elder Law show, you will see that asset protection after death is huge in our firm. It's huge in what we believe in, because we believe that the money should go where you want it to go, protected for them and only for them, so that spouses, car accidents, nursing homes can't take it. But when you take the step to avoid probate, right, you're most likely giving up the ability to do that. Now, we're going to talk in subsequent podcasts about doing asset protection after death in a revocable trust, which, yes, it would avoid probate, and yes, we can still do asset protection after death. So that is the solution to be able to do it and to avoid probate. But most times people don't do that. They just simply beneficiary designate it and think that, oh boy, I've avoided all these fees, I've avoided attorneys, I've avoided everything else. Well, you did. And you also avoided the probability of the inheritance taxes being paid through the estate so that the beneficiaries are receiving the money free and clear and they don't have to worry about it, and potentially other issues as well. So what we recommend at Belomo and Associates in our workshops, which we provide on a regular basis, we have workshops for estate planning, pre-planning, crisis planning, probate admin, trust admin, special needs planning, is that not always is the easiest thing the right thing. We recommend protecting future generations, spouses, protect the money so that they can't lose it to a nursing home, to a car accident. We will certainly go in much more detail on a future podcast as to how that works. But today, we just wanted to talk a little bit about probate versus non-probate, what the differences were, what it means, and why simply avoiding probate at all costs isn't always the best decision, and it's not always needed, frankly. Although we will talk later about how we recommend doing the asset protection after death. So, I'd like to thank you very much for joining us today. Remember, folks, the advice you received today should not be taken as legal advice, and you should not make any decisions based upon the advice that you heard today. Please seek out counsel in the state that you live, someone who is licensed in that state. If you're in Pennsylvania, we'd love to help. We can't thank you enough for joining us for the Red Wagon Estate Planning and Elder Law Show with me, yours truly, Jeffrey Belomo. Until next time, we'll see you real soon.